Topics in Volume 2, Chapter 7, Part 1 of 2. Income tax returns. New persecutions by the administration. The capitulation of the administration. The ignominious end of 7 years' persecution. Letters of Edwards Pierrepont, Special Counsel for the Government. S. L. Woodford, United States District Attorney. Green Arp Raum, United States Commissioner of Internal Revenue. Charles J. Folger, Secretary of the Treasury. And Benjamin H. Brewster, Attorney General of the United States. The income tax suit. The administration at Washington, not content with violating the sanctity of private correspondence for material with which to discredit the candidate of the Democratic Party, did not scruple to avail itself of other resources exclusively within its own control, and with despotic recklessness. In the latter part of August, 1876, an article appeared in the New York Times, the favorite New York organ of the administration, charging Mr. Tilden with having sworn to false returns of his income, and giving various specious statements of his sources of income purporting to show a substantial discrepancy between its amount and the amount which Mr. Tilden returned. The time selected for this assault betrayed the unworthy motives which inspired it. It was in the high noon of the presidential canvass, in which, of course, all of Mr. Tilden's energies were enlisted. His brother Moses was lying on what week or two provided to be his deathbed. Mr. Tilden had not found time to complete his letter accepting the nomination of the St. Louis Convention, to which his spare moments, usually taken from hours that should have been given to repose, were devoted. It was under these peculiarly trying conditions that he was suddenly and altogether unexpectedly called upon to review the history of transactions already 14 years old, of which he had preserved scarcely a scrap of memoranda. More than 6 years had elapsed since he had retired from the active practice of his profession, subsequently to which he had rarely visited his office even for matters of private concern. Add to all these embarrassments, the ruthless hand of one of the same cabinet ministers who subsequently engineered the electoral frauds in Florida and Louisiana was here visibly directing the blow that was aimed at his honor through the columns of the Times. Of course, such a charge with what appeared to be official specifications, including a facsimile of Mr. Tilden's income tax return, which could only have come from the Department of the Interior, of which Zachariah Chandler was the official head, produced a profound sensation throughout the country. Mr. Tilden's character was of more importance to him than the presidency, and inconvenient and laborious as it was, he felt himself compelled to devote several weeks, with the aid of 3 or 4 clerks, to evoke from the scattered records of the past, evidence of the false and malicious character of these imputations. With the aid of Judge Sinnott, who had been his confidential law clerk during the period covered by the Times, he prepared a statement which was published on the 20th of September. The Nation, of the 28th of that month summed up the whole case, so far as the main charge of making a false return, perjury, etc., was concerned. Note: Tilden and his staff made a chart proving every dollar the Times published was a lie. For the period subsequent to that covered by this table, the Times had charged Mr. Tilden with allowing the income tax assessor to assess his income at less than its value. The absurdity of this charge leaped to the eyes of every reader. In the first place, not only in New York, but in every state of the Union, property is assessed for taxation by an official assessor, and the taxpayer is never required to make a statement of the amount or value of his property except in pleading for a reduction of his assessment. In the second place, the income tax law expressly provided that in case the taxpayer omitted to make a return of his income, it should be assessed by the assessor. It was so assessed and paid. The terms of the law had been compiled with, and, as Mr. Tilden confidently affirmed, he paid more those years than would have been required had he made his own returns, which he neglected to do only because the difference was not worth the time and trouble it would have cost him, to apportion to each year the precise amount saved during that period, in litigations covering a series of years. Mr. Tilden's answer effectually disposed, for the time being, of these charges, which in the somewhat emphatic language of a journal of the period, can be characterized in no milder terms than a vicious lie, a base slander, and a diabolical calumny. The assault had utterly failed of its purpose so far as any effect upon the election was concerned, upon which, if it had any, it seems to have been a favorable one, but the extra toil and worry to which it subjected Mr. Tilden for several weeks during the hottest season of the year, told seriously upon his health and no doubt contributed to shorten his days, in that respect serving the purpose of his tormentors by contributing to disqualify him for the duties of the chief magistracy for years later, to which, had his health permitted, he would have unquestionably have been chosen. Unhappily for Mr. Tilden's peace, he was still too formidable a political force to be neglected. He was regarded by his party, with practical unanimity, as its inevitable candidate for the presidency in 1880. Thought the assault upon his character had thus far ignominiously failed, the resources of the administration's arsenal of defamation had not yet been exhausted. It had charged Mr. Tilden with making false returns of his income. He had denied it, and the public had accepted his denial, but the administration had prosecuting attorneys and a judiciary all of its own appointment. Why not institute proceedings for the money of which it was alleged the government had been defrauded? That course would at least vindicate in a measure the part which the administration had had in promulgating the original calumnies. It would keep the question of Mr. Tilden's innocence measurably open for partisan uses. It would worry and wear upon their victim, who had no health to spare for litigation. It would induce some who wished to be confirmed in their fanatical hostility to the Democratic Party, to believe that where there was so much smoke there must be some fire. By that wily procrastination, of which the law officers of the federal government have almost unlimited control, the innocence of Mr. Tilden could not be established until after the suspicions thus propagated of his guilt might have accomplished their perfect work. Accordingly, a suit was instituted at the instigation of the Hayes government against Mr. Tilden, shortly after the election in 1876, to establish what subsequently was admitted to have been a purely imaginary liability for unpaid income tax. The commencement of this suit was duly heralded through the press. Several months elapsed before Mr. Tilden was furnished with any statement of the grounds of the government's claims. No serious attempt was ever made to bring the case to a hearing, but it was nursed along to be used as convenient means of presenting Mr. Tilden to the country from time to time in the attitude of a culprit. These knavish tactics were pursued throughout the term of the Hayes administration. When the suit had been pending for a year or more, the government was forced to admit that it was not in possession of any evidence upon which to sustain its suit, and then had the effrontery to file a bill of discovery to compel Mr. Tilden himself to furnish evidence upon which their prosecution could be sustained. To this Mr. Tilden of course demurred, regarding it as practically an admission that the government had no cause of action. Judge Blatchford, who was sometimes a judge and always a politician, decided against the demurrer. Pending the litigation over these proceedings, President Hayes and his associate beneficiaries of the frauds by which he had been installed in the presidency were dismissed from the public service, and a new government replaced them. Meantime, Mr. Tilden's health had been steadily declining. He had ceased to be regarded as a candidate for the presidency, and there was no longer, therefore, any motive, if there had been any disposition on the part of the new administration, to persecute or defame him. The question now was how to rid of the suit without compromising those who instituted it. That story may be best told in the language of the parties who conducted the retreat. We will commence with the following memorandum of facts prepared for the counsel by Mr. Tilden himself. Tilden's Memoranda for Counsel. In compliance with your request, a memorandum of certain facts involved in the income tax case, discussed in our recent conversations, is furnished. 1. The action against me is, so far as is known or can be ascertained, the only suit of this nature which has been instituted and prosecuted. The suit against Mr. Hazard was for taxes accruing during a portion of the period when the income tax existed. The amount claimed was over $150,000, and the interest enlarged the claim to at least $250,000. In the settlement, the United States amended its declaration so as to embrace the whole 10 years of the income tax, and to fix the judgment, including principal and interest, at $1,000. Judgment was taken by consent, and the appeal was waived. Mr. Hazard told me that he settled it because it was cheaper to pay such a judgment than the cost of counsel fees. See the letter of Honorable Charles Bradley. Mr. Hazard's counsel points for defendant, page 21. 2. The allegation on which the United States rely in the action against me is merely that the assessor did not make the assessment large enough. That naked proposition is aided by no other statement whatsoever. The claim as stated in the declaration applies equally in the years in which I made a return and in the years in which I omitted to make a return. No distinction is intimated whether the taxpayer makes a return or leave the ascertainment exclusively to the assessor. The consequence is that the pretensions in behalf of the United States, to review by a court and jury the action of the assessor, extends to every case in which assessment was made during the whole 10 years. Mr. Harland, who is familiar with such subjects, estimates that there were some 4 or 5 millions of assessments. In every one of them, on the theory of this suit, an action could be brought, treating the assessment as a nullity, and making a new assessment by a court and jury. As there is no limitation against the United States of the time for bringing an action, every citizen once liable to the income tax remains exposed to such an action as long as he lives, and his property remains subject to it as long as anything of his estate can be traced. Other grave questions arise. For instance, the statute of 1864 expressly declares that the amount due shall be a lien in favor of the United States from the time it was due until paid, and the lien follows the property into and through the hands of innocent third persons. 3. By Section 3214 of the United States Revised Statutes, such an action could not be commenced unless the Commissioner of Internal Revenue authorized or sanctioned the proceedings. The letter of Commissioner Raum, giving his formal approval of the action against me, was dated January 25, 1877. The capias, unaccompanied by any declaration, was issued January 22, 1877, and served on the 27th. It is noteworthy in this connection that under date of January 3, 1877, Commissioner Raum had addressed to Mark Bangs, United States District Attorney at Chicago, in answer to a letter dated October 27 previous, an elaborate opinion that the decision of the assessor, when an assessment is in the scope of his jurisdiction, cannot be questioned collaterally. You will find the whole opinion on pages 17 to 22 of defendant's points. The Commissioner thus appears as having authorized this suit 19 days after he had given formal official opinion that such a suit is not maintainable in law. His opinion is published in the Internal Revenue Record of January 8, 1877, and was accessible to the District Attorney more than 2 weeks before the suit commenced. For, not only did the District Attorney who brought the suit action, and the Commissioner of Internal Revenue who authorized the action, know at the time, by such high and, to them, conclusive authority, that there was no basis in law for the action, but they were equally destitute of any evidence in their possession to constitute a basis of fact on which to justify the action if it had been maintainable in law. They had nothing but newspaper fabrications, got up in August, September, and October, 1876, during the presidential canvass, every item of which on being analyzed fails to be probable cause or was disproved at the time. I will not go over these in detail. One illustration will suffice. The main attack was made on my return for 1862. The only tangible fact alleged was that in one case I had collected during that year sums for compensation and disbursements which has accrued wholly, or almost wholly, during previous years beginning as far back as 1857. Now, I happen to have in my possession the identical copy of Boutwell's manual, used by my managing clerk in making out the return for 1862, and it contains an express decision of the Commissioner of Internal Revenue, announced in May, 1863, that the earnings of a lawyer during the previous years are to be excluded from the return, although collected during the year for which the return was made. Mr. Harland, at the time he put in a plea forming an issue of law in the case, mentioned to me that Mr. Sherman said to him that if he had had the management of the defense, he should have waived the issue of law and gone to trial, because the district attorney's office had no evidence to sustain the action. 5. The capias was issued by District Attorney Bliss 2 days before his successor, District Attorney Woodford, was sworn in. It was served on the 27th. It claimed the round and exact sum of $150,000 as taxes and penalties. It was unaccompanied by any declaration specifying details of which the claim was composed. The complaint was filed on the 14th of April, or about 3 months later. It aimed to make up the gross claim state in the capias, by alleging an income sufficient to produce the tax. It alleged $2,703,600 of income over and above all on which taxes had been paid, and over and above all lawful deductions. It distributed this immense sum over the 10 years, except $100,000, which it claimed for 1861 when there was no tax. It made this distribution on conjecture or arbitrarily. To 1865, which was a year of universal disaster, following the fall of gold and collapse of values resulting from the close of the war, and a year in which unquestionably my income was less than the sum I paid on, it absurdly assigned $333,000 of the excess of income. This immense pretended excess of income is a mere myth. For 1862 and 1863 I submitted returns. They were carefully made out by my chief managing clerk, who was a counselor at law, and the habitual expert of the office on questions under the revenue laws. He had access to every source and means of information, and no instructions except a caution against assuming any doubtful question for me to verify. He has now no doubt that the returns were correct, except that they leaned towards the government. Nor have I, in the years when no return was made, I do not feel responsible for the assessment of the assessor. It is the universal practice of the state of New York for state, county, and city taxes to be computed on assessments made by the public officers on their own information and judgment. The citizen has a statutory privilege to interfere for the purpose of obtaining a reduction of the assessment, but never interferes for any other purpose. I never heard it suggested, even if the assessment were less than the real value of the subject of taxation, such assessment being made by the assessor on his own information and judgment without interference by the taxpayer, that the taxpayer would be held to be morally culpable. I never heard it suggested that the state, country, or city could afterward sue the taxpayer for a larger sum than that which it had so assessed and collected by its own officers. The United States income law expressly provided the alternative for the taxpayer, if he chose to leave the assessment to the public officers, and to accept the enhancement of the assessment as a consequence of making no return. It was the policy of the revenue law to make the discretion of the assessor supreme and conclusive. Even if returns were made, the assessor had the power to add to return or to disregard it, and generally to make his own assessment from such information as he might choose to rely on, and to be governed absolutely by his own judgment. I discontinued making returns in 1864 because of the total impossibility of solving questions of law which they involved, and at the time when I believed I would pay, and did pay, under the fiat of the assessor, a larger tax that I was properly liable to pay. In point of fact, however, I generally paid a larger tax that I ought, and probably did so in every year, unless that result should be changed by eccentric constructions of the law. It is my belief that during every one of the 10 years I was holding railroad bonds and stocks and other securities, on which the tax was deducted from the interest and withheld before the income reached me, to so large an amount that the income thus taxed was a greater sum than my whole real income from investments. In other words, the interest paid out by me was always larger than the income from that portion of my investments on which the tax was not collected by the government through the corporation that issued the securities. During the 8 years, 1864 to 1871 inclusive, the average amount imposed by the assessor, including his additions for the omission to return, was about $27,000. I estimate the aggregate amount of office expenses which come out of the gross receipts before the net income is ascertained, and of taxes and interest paid out, which are lawful deductions from income, could not be less than $30,000 a year. I estimate that the amount of income on which the tax was collected through corporations issuing securities ranged between $20,000 and $100,000, and could not be less on the average than something between $40,000 and $50,000 a year. That would make the gross receipts over $100,000 a year, and the income paying tax between $70,000 and $75,000 a year. Growth of values of property not sold, whether real or personal, is not income. Gains from real estate converted, unless the real estate has been purchased within 2 years, were excluded by statutory definition. Accretions from the conversions of bonds and stocks, unless they were bought within the same year, were deemed not to be taxable by the Supreme Court of the United States in Gray v. Darlington, 15 Wallace. Excluding those 3 classes alone, and there are other classes of exemptions from tax, I believe the growth of all my property during the 8 years did not make good the actual realized losses incident to the unsound finance of the time, and furnished the amount on which I paid the income tax, less the cost of living. The Parthian arrow of the retiring district attorney was aimed at his successor, and was so understood by Mr. Woodford. It had the additional purpose of lending an appearance of reality and consistency to the electioneering devices used during the canvass of 1876. 6. As early as the last of August, 1876, and then district attorney indulged in an interview menacing the suit, and later during the canvass he published a report to the Commissioner of Internal Revenue on the subject. Those officers freely used and abused their official characters and official functions to give credit to the electioneering falsehoods of the canvass. 7. After the amazing decision of Judge Blatchford was rendered, that in every case whatsoever where there was a return and where there was no return the United States may at any indefinite time afterwards impeach the quasi-judicial decision of its own assessor, set it aside on the naked allegation that the assessment was not large enough, and retry the questions of the amount of a man's income by a court and jury, involving countless issues of fact and of law, my counsel sought the speediest review of his decision by the Supreme Court of the United States. The technical difficulty was interposed that an appeal could not be had except after a judgment. To obviate that, my counsel offered the district attorney to let judgment be taken on the last count, which was for $100,000 of income that never existed, providing by stipulation that the action might be renewed as to the other counts, and that the United States might take testimony to bene esse, subject to future exception, as its option. They were not able to obtain this arrangement or any arrangement without allowing a judgment to be taken on an enormous amount of fictitious income. The government and defendant are therefore brought to confront a hypothetical trial in a case where it is believed that there is no legal ground of action, even if the government could prove its allegations of fact. That hypothetical trial involves every transaction during a period of 10 years, every item of income, and every item of deduction for expenses, for taxes, for interest, for losses by bad debts, by bad investments. It is claimed that such an impalpable element as the increased value of the assets of a company which never made a dividend during the 10 years, nor was ever able to collect enough of its means to pay its debts till the last year, is to be counted as income of an individual stockholder, estimating his share in the ratio of his stock. That item alone would involve all the transactions of a mining company for 8 years. I mention this as an illustration to what interminable collateral inquiries and controversies such a suit so carried on may lead if the plaintiff chooses to give it that character. 8. It is impossible to conceive of a case in which every reasonable consideration is more urgent than in the present, in favor of settling the questions of law in advance of the trial of the questions of fact. In the first place, it must be admitted that there is an extreme improbability that the Supreme Court of the United States would sustain the decision of Judge Blatchford, and overrule the immense series of cases in the courts of the United States, of the different states, and of England, establishing the principle that the quasi-judicial decision of the assessors and similar officers is conclusive. I cannot suppose that the Attorney General, still less that such a jurist as Mr. Edwards, would have any doubt upon the subject. In the second place, a rule which subjects every citizen of the United States liable to the income tax in any one of the 10 years to have his tax reopened by a suit, which continues that exposure indefinitely, cannot but be considered a question of great public importance to the mass of taxpayers as well as of great interest to the government. Such a question ought to be settled at the earliest moment by the highest tribunal, and put forever at rest. The offer of my counsel was immediately to carry a judgment to that tribunal, and to unite with the Attorney General in an application for an immediate argument, which would no doubt be granted on motion of the Attorney General. As the United States were not ready at the December term, and recently intimated in court that they would probably not be ready for the February term, no loss of time would result. In the third place, there would be a great convenience to the United States and the court in avoiding a hypothetical trial. The case has uniformly been spoken of by the district attorney and by Judge Choate as a long case. How long it will be will depend on the district attorney. It is quite capable of being ramified to take a whole term or a great many terms. The pretension was set up by the Marquette testimony that the defendant's income should involve, not the dividends declared, not the profits ascertained or adjudged by a corporate act, but the unrealized constructive profits of a company that had at no time been able to pay dividends. That one item would bring into the case all the corporate books for 8 years, and more issues of fact than would be comprised in 50 ordinary lawsuits. On such a system, a case which includes all the transactions of 10 years ought to take a lifetime. The very existence of such a case illustrates the utter absurdity of the notion that assessment of income is a thing fit to be done by a court and jury. In the fourth place, to insist on a hypothetical trial because of the technical difficulty of appeal, or to impose onerous or impracticable conditions not necessary to the interests of the United States, indicates a purpose to conduct the suit merely in such a manner as to harass, oppress, and defame the defendant. The case has been suspended over the defendant for 2 years. It is noticed for each successive term, but the United States is never ready. The defendant returned from Europe in October 1877, influenced largely by necessity of attending to and the expectation of disposing of this case. He will some time or other want to be liberated from the necessity of being in attendance at each successive term. The expenses and other burdens of such a controversy, with roaming commissions such as those at Boston, Pittsburgh, Chicago, and Marquette, ought not to be imposed upon a citizen unless the action is untamable in law. 9. The Attorney General, in Section 362, United States Revised Statutes, is commanded to exercise a general superintendence and direction over the district attorney. The function of the Commissioner of Internal Revenue is limited to an asset to the bringing of a suit. After the suit is brought, the power and responsibility belong to the Attorney General. Nor can it be doubted that all questions as to the legal rights of government and its public policy are within the domain of the Attorney General. 10. Such a case ought to be acted on with reference to general considerations of public policy. If the millions of cases in which an income tax was paid are all open to review as a matter of law, and it is wise and right and conformable to public policy to undertake a revision of them, there ought to be a systematic inquiry by competent machinery applying alike to all citizens. The whole action of the government ought not to be descend into a mere raid of one citizen. A few days before the meeting of the first Congress after the accession of Garfield to the presidency, the following letter was addressed by Vanderpoel, Green and Cumming, of counsel for Mr. Tilden, to the Honorable Edwards Pierrepont, Special Counsel of the Untitled States. Vanderpoel, Green, and Cumming, No. 2 Wall Street, New York, December 3, 1881. Honorable Edwards Pierrepont, Special Counsel, Sir, in reference to the case of the United States against Tilden, while believing that the action must result unfavorable to the United States, upon the law, if ever the case can reach the Supreme Court, and upon the facts, whenever a trial shall be had. I recently expressed to you my conviction that the United States ought now to be willing to discontinue the action on their own motion, but that I could yet understand that some embarrassment might exist by reason of expenses for which the United States may become liable relating to the future as well as past conduct of the case. I have considered the very great burden to both parties of a futile trial, in a case which theoretically involves an inquiry into every transaction of an active professional and business life, during the 10 years ago, a futile trial which would swamp a court and jury for an indefinite period, unless the controversy should be limited by the inability of the United States to produce evidence except as to a very small fraction of the things they draw in question by their claims, as asserted in their complaint. I have considered, also, that next month it will be 5 years since this action was commenced, that, as I suppose, at no time have the United States been really ready for trial, that when the present district attorney inherited this action, he found in his office no facts or evidence by which to frame a complaint, that 2 years later the United States, in a bill of discovery, placed on the files of the court an avowal that they then had no evidence on which they could safely proceed to trial. That at the present time, I believe the United States have not at all improved their condition in this respect, that, nevertheless, the defendant may be subjected, for years to come, to the necessity of preparation for each successive term, while totally unable to obtain a final termination of the trial, and that the defendant has been frequently compelled, at great expense and inconvenience, to send counsel 500 or 1,000 or 1,500 miles to attend upon fishing excursions, in the form of commissions to take testimony de bene esse, in which the commissioners could not exclude, but which are not admissible as evidence in the case. I have also considered that, notwithstanding the inexpediency of subjecting either party or the court to trouble or costs of a hypothetical trial, in a case in which there is every probability the Supreme Court will hold as matter of law that there is no cause of action, every expedient for first presenting the question of law to that tribunal has failed, that, notwithstanding the concurrence of all the leading cases in England, in the several states and in the United States, that the quasi-judicial judgment of a taxing officer fixing the amount of the tax is conclusive upon the government, as well as upon the citizen. And an elaborate opinion of the Commissioner of Internal Revenue, dated January 3, 1877, to the same effect, the interlocutory ruling of the district judge on the demurrer in the case debars an appeal to the Supreme Court until after final judgment at the trial, that, in the ordinary course of things, it would probably take from 3 to 5 years to obtain a decision of the Supreme Court on the case, and that could be obtained only in the contingency that a judgment should be rendered for the United States. Considering all these matters, I repeat the suggestion made to you that the United States proceed to discontinue their action, and that they be relieved, by arrangement with me, from the expenses, including counsel fees, which the untied states have incurred or become liable for. The amount of such expenses, whatever they are, cannot but be small compared with those which each party must hereafter incur, if the case goes on. Very respectfully yours, etc., A. J. Vanderpoel. The successive stages of the government's capitulation will be found set forth with sufficient detail in the several communications following. Edwards Pierrepont, Special Counsel for the United States, to the Acting Attorney General of the United States. The Hon. Samuel F. Phillips, Acting Attorney General of the United States, in the suit of the United States against Samuel J. Tilden to recover income tax, I have the honor to report that after my retainer, on the 8th of March 1880, I devoted most of my time for an entire month to the investigation of the statutes, the judicial decisions, the very long depositions, the examination of witnesses, the laws relating to the admissions of evidence in the case, and to very many consultations with the United States Attorney, General Woodford, and his assistant, Mr. Clark, aided by Mr. Webster, of the Internal Revenue Service, to whose intelligent activity and zeal is largely due the discovery of the more valuable evidence in the case. The matter is complicated, and the difficulties of reaching a satisfactory conclusion are increased by the great lapse of time. Mr. Tilden's first return for the year 1862. Brief history of the case. After Mr. Tilden was nominated for the presidency by the Democratic Convention June 1876, this action was commenced. Up to that time no charge had been made by any officer of the government that the defendant was in default. The summons was served under the order of the last district attorney just before he went out of office, and the suit came by inheritance to General Woodford, the present district attorney, who prepared the complaint. The complaint contains 12 counts, and demands judgment against the defendant for $128,442, besides interest for many years, and costs of the action. Prior to my retainer in the case, in March, 1880, the district attorney, General Woodford, having collected and examined all the evidence within his reach to warrant him in proceeding to trial, accordingly filed a very long bill of discovery against the defendant, as the only means left by which sufficient evidence could be obtained. The bill specifically states that there is not sufficient evidence to be had without resort to a bill of discovery. To this bill a demurrer was interposed, and the questions raised by the demurrer are now pending before the Supreme Court. In the bill filed for discovery, the plaintiff avers that for the years 1862 and 1863 the defendant made returns of his income, but that the same were not true returns, and that for the years 1864, 1865, 1866, 1867, 1868, 1869, 1870, and 1871 the defendant neglected to make any returns, and that in default of such returns the proper officers estimated the amount of the defendant's income for said years, and assessed the tax thereon, together with the additional penalties prescribed by law. Which tax, additions, and penalties prescribed by law, which tax, additions and penalties so assessed, the defendant paid to the officers authorized, etc. The Act of 1864, as amended by the Act of March 3, 1865, 13 statutes at large, 480, provides, that it shall be the duty of all persons of lawful age to make and render a list or return of the amount of their income, gains, etc., and in case any person shall neglect or refuse to make and render such list or return, or shall render a false or fraudulent list or return, it shall be the duty of the assessor to make such list, according to the best information he can obtain, by examination of such person, and his books and accounts, or any other evidence, and to add 25% as a penalty to the amount of the duty on such list, in all cases of willful neglect, or refusal to make and render a list or return, and all cases of a false or fraudulent return, to add 100% as a penalty. The penalty for neglect to make returns was increased to 50% by the Act of March 2, 1867, 14 U.S. Statutes at Large, page 479. There is no charge that the returns made were false and fraudulent for the years 1862 and 1863, when under oath the returns were made, and I find no evidence that they were not correct, and if the case tested on those years alone, I am clearly of opinion that the government would dismiss the suit. I, therefore, consider the question only which relate to the years 1864, 1865, 1866, 1867, 1868, 1869, 1870, and 1871, when the plaintiff alleges that the defendant neglected to make returns, and paid the tax and penalties prescribed by the statutes. The above cited prescribes in definite terms the duty of citizen relating to returns of income, and in case of neglect imposes a penalty, and specifically directs how the assessor shall make a list for return and imposition of the penalties. The defendant denies all the material allegations contained in the various counts of the complaint, and, as a specimen, add, and for a further and separate defense to the 7th, 8th, 10th, 11th, and 12th causes of action contained in the complaint, the defendant alleges that he neglected to make a list or return, and that after said neglect for each of said years the assessor made a list of defendant's annual income, and did assess the duty thereon, and did add 50%, as a penalty, all of which tax and penalties the defendant paid to the collector. To these pleased the plaintiff demurred, and Judge Blatchford, in a very elaborate opinion, sustained the demurrer, thus holding that the payment of the tax assessed, and the penalties imposed, did not discharge the defendant from further liabilities, notwithstanding the lapse of time and the absence of any charge that the assessor had been deceived or misled by any concealment or other act on the part of the defendant. I am not aware that his direct question had ever been decided by the Supreme Court of the United States, and until it is thus passed upon, there is likely to be much difference of opinion as to the law of this case. The question will of course arise on the trial, and its discussion in presence of the jury will, however irregular it may be, tend to bias their minds in favor of the defendant, on the ground that when the citizen had paid all the tax that the law seemed to require, with heavy penalties for his neglect, added exactly as the statute directed, and no charge of fraud, deception, or concealment is made, and the money is received and the receipt given, and years had been allowed to pass without any suggestion of the assessment or penalty being too low, it would not be equitable or just, so long after the repeal if the law, to impose a new burden. Of course, as this is a pure question of law, the jury would have no right to consider it, except as directed by the court, but I have had too much experience with juries not to be aware that they will consider it, and that it may be an excuse in some of their minds for refusing to find facts necessary to a recovery by the plaintiff. If it be decided that the payment of the tax and penalty is no bar to the action, then a legal question will arise as to the burden of proof. As a sample of the counts, take the sixth. The complaint avers that the defendant in the year 1865 had gains, profits, and income from various sources, amounting to $332,000, in excess of the sum of $600, and in excess of the sum which was subject by law to a duty at a lower rate than 10 per centum, and also in excess of the sums which he was entitled by law to deduct from his said gains, profits, and income, was estimating the amount thereof upon which he was required by law to pay a duty for said year, and also over and above the sum paid within the said year, by said defendant, for the national, state, county, and municipal taxes upon his property or other sources of income, and also above losses sustained by the defendant for the rent of the homestead used or occupied by himself or his family, and above losses sustained by the defendant upon the sales of real estate purchased by him within said year. The defendant takes issue. If the plaintiff must prove the charge as laid before we can get judgment, then the income of the defendant for a given year was $50,000, and their rest, and the defendant says nothing, for what sum can we demand judgment? We sue for a sum over and above the statutory deductions, which is all that the law allows. We should be in difficulty unless the court held that the burden of proving deductions was thrown upon the defendant. Would the court so hold after the taxes and penalties imposed by the proper officers had all been paid? After this great lapse of time there is much difficulty in getting at such evidence as the court will receive. Every witness who knows anything of value is unwilling, some fear exposure of their own delinquencies, others profess forgetfulness, and the difficulty in reaching legal and reliable testimony is nearly insuperable, and it is quite certain that the tendency of the jury will be against overhauling stale claims for taxes when the defendant has paid all that assessors impose. With heavy penalties added, and especially as no charge is made of deceptive concealment, since the suit was not commenced, and no fault found until so many years after, when Mr. Tilden was nominated for president, political considerations will be likely to enter into the trial of the cause and may influence the verdict. The report of Mr. Webster, an officer of the Internal Revenue Service, upon whom we rely to furnish the only valuable evidence, was strongly against risking a trial in April, 1880, as his report on file shows, and after a very careful examination of all the evidence which we can now produce, our case is in no respect stronger, but rather weaker than in 1880. The District Attorney, General Woodford, in a late communication to the President, is of opinion, in which I concur, that the action ought to be dismissed, which communication of the District Attorney to the President, and which is referred to the Attorney General, I ask leave to make a part of this report. We had hoped to elicit very valuable, though most unwilling, testimony from Mr. Lanier, a banker of New York, and on account of his infirm health we tried repeatedly to take his testimony conditionally, but we failed by reason of his feeble condition of health. Last July we obtained an order for his examination, but he was still too ill to be examined, and soon after he died. We had expected to obtain valuable evidence from a cross-examination of the defendant, but his physical condition makes success in that way quite improbable. If the action is to be tried, a laborious preparation is essential and should begin forthwith. The trial will take from 6 weeks to 2 months and will be attended with very large expenses to the government. If the case is to be dismissed, the terms of the dismissal will require your consideration. The defendant offers to reimburse the government its expenses. It has been suggested that the government should dismiss the action without costs. I should be of that mind if convinced that there was no reasonable ground for commencing it, but I do not entertain that view. I regard this as a case where for various causes we failed to obtain the legal evidence to maintain the action, and I think it would be just for the government to exact as a condition the payment of expenses incurred. In suit against Hazard, in Rhode Island, the government claimed over $150,000, which with interest amounted to some $250,000. It was settled for just $1,000. So far as I can learn, this suit is the only one in the entire United States which has been prosecuted, except the above Hazard suit mentioned. My opinion is that the suit ought to be dismissed on the terms proposed. I have the honor to remain, etc., signed, Edwards Pierrepont, Special Counsel for the United States. Office of the United States Attorney for the Southern District of New York. New York, December 10, 1881. Note: there seems to be evidence that for the year 1868 Mr. Tilden made returns, but neither the complaint, answer, or the bill of discovery so treat it. United States District Attorney to the Commissioner of Internal Revenue. End of Chapter 7, Part 1. Continue on to Chapter 7, Part 2, Tilden vs. United States, the Income Tax Lawsuit.